Welcome to Employment Law This Week. I'm George Whipple. Our top story, the California Supreme Court clarifies the state's ambiguous day of rest provisions. The provisions state that, with certain exceptions, employers will not cause employees to work more than 6 days in 7. The state's High Court addressed 3 questions around this law that have been certified by the Ninth Circuit. First, the court determined that employees are entitled to 1 day of rest per work week. Every Sunday marks the beginning of a new 7-day period. The court also clarified that employees who work 6 hours or less during each day of the work week are not entitled to a day of rest, and that employees can choose not to take the day of rest if they are fully aware of the entitlement. Kevin Sullivan has more.
Many California employers have staffs that work 7 days a week. They have operations that are 7 days a week. And those staffs are entatled to 1 day of rest within a work week. And the decision is quite important for those employers because it defines an employer's obligation that while an employee is entitled to a day of rest within 7, the employer cannot cause that employee to forego that entitlement or to make them work that 7th day within a single work week. And so the California Supreme Court decided that an employer has an obligation to apprise employees of that entitlement and to remain neutral and leave the decision whether to work that 7th day up to the employee, him or herself.
The 10th Circuit holds that quid pro quo and hostile work environment harassment can be based on the same facts. A male mechanic filed suit alleging both quid pro quo and hostile work environment discrimination, claiming he was terminated for refusing the advances of his female supervisor. In his initial EEOC charge, the mechanic said only that he was harassed, but did not include any further details. The district court dismissed all of the claims except for the hostile work environment claim, finding that the quid pro quo claim was not raised in the EEOC charge. A split 10th Circuit reversed, holding that the details of the quid pro quo claim were not needed in the EEOC charge for the claim to survive, because quid pro quo and hostile work environment harassment are not separately recognizable claims under Title VII. A district judge in Florida has ruled that a citrus company is a joint employer with a labor contractor who supplied it with workers. The case involves a class of over 150 guest workers under the H-2A visa program who allege that they were not paid proper wages. The labor contractor that hired and supplied the workers maintained control over their transportation, housing, and equipment. But the judge found that the citrus company's control over their work, method of payment, benefits, and location of the work supported a finding that the citrus company was a joint employer. Georgia ushers in new employment laws. A new state measure favoring businesses that use on-call or predictive scheduling prohibits cities and other local governments from mandating additional pay for canceled shifts and schedule changes. And the newly signed Family Care Act requires businesses with 25 or more employees that provide paid sick leave to allow employees to use 5 of those days to care for immediate family members. Both laws will go into effect July 1st, 2017. Finally, it's time for our tip of the week. Jonathan Baer, Managing Director, General Counsel, and Chief Compliance Officer for Sagen Advisors, is here with some advice on the best way to protect your firm. We caught up with Jonathan at the SIFMA conference in San Diego.
I think it's important that you protect the firm. It's one of the key components of our job, if not the primary component of it. But it's important to protect the firm while being commercial. And it's important to be user-friendly. And at times you may have to say no to the business team. It's better if that's a collaborative effort between the business and the legal department. You don't want to be a hindrance to doing business. So it's important to get buy-in from senior management.
Thanks, Jonathan. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.